Oh, all right. I now call this meeting to order. The time is, I'm blocked out of the time. The time is 8:37. And the Oregon Board of Physical Therapy is entering public session for the purpose of roll call. Michelle, can you please call or roll call?
Yes. Tim,
Timothy Brinker, present.
Aaron,
I'm here.
Sandra,
Here.
Hoku is excused. Michael,
Here.
Susan,
Here.
Erica is excused, and Dwight is also excused. For staff present, Michelle, Sherry,
Here.
Gayla,
Here.
Sarah,
Here.
Joanna.
Here.
Madam Chair, for the record, there are no members of the public currently present at the meeting.
Thank you. So are you going to go into the slides?
Sure. Ready for
Okay.
me? Okay.
Yeah.
The first piece on the slide, and I'll adjust the slide for a better fit. Watch your eyes for a moment. Just to note, the statutory purpose for the Board of Physical Therapy is to protect the public health, safety, and welfare for all Oregonians by maintaining standards for quality care, professional skill, and competence through the effective regulation of the practice of physical therapy. With that, the first item is the consent agenda. This is information that is sent to the board members ahead of the meeting so that they can review that and streamline the discussion. All the materials that you're seeing today on the screen, if you're watching the video, will also be posted later today on the website and available for download. Consent agenda for today includes the minutes of the last meeting, the ratification report of licenses issued, and the director's report and financials. The couple of highlights I do want to note, if you are looking at the materials, a caution to not necessarily print out the entire document because this report includes part of the renewals from the period of March. There are, I think, roughly 87, 90 pages just for the licensing actions associated with renewals that the board ratifies the issuing of that. So I'm going to skip ahead through those pages. Almost there. And I wanted to highlight a few things on the executive director's report. We are getting close to the end of the first fiscal year in the biennium for the state. We are also through the renewal season, which means the largest window of revenue that the board accumulates is now behind us. So you'll start to see a shift back to where expenses outside of renewals will typically exceed income, which is to be expected because of the fixed date for renewals. A lot of education and outreach because, of course, it's graduation season. So Sherry and Gayla have been out in the field meeting with students to help with a successful transition into licensure and exam. And also some highlights on Sherry in particular has been doing a number of outside presentations with different groups. Many of those are available from the organizations and can be watched without a membership. Administrative highlights, of course, we're to the end of renewals. Sarah will provide an overview and some analysis on data out of renewals. Just a note here that we are in the period of lapsed renewal, and we typically wait 90 to 120 days before we open up the ability for licensees to enter in their continuing competency information for this current plan year. So we're getting close to it. For this time, it's going to be a little longer, so closer to the 120 than the 90. And the reason for that is the deferred migration for the licensing system. We don't want to add any complexity before we do the migration, before we have folks do a lot of entry into that. So that's part of that. And then the last point there is just to highlight on the diversity, equity, and inclusion and belonging efforts that are statewide. The state has formed a cohort, different cohort groups for different types of agencies. We are in the health professional regulatory cohort, which has started meeting, and I will have information for that. We are deferring that to the July meeting when more of the members are able to attend for that discussion. In your licensing stats, of course, we have the expected drop-off in total licenses as we have post-renewal. The new chart that you see down here with the percentages shows you historically the type of drop-off that we see with non-renewed licensure. So this year is actually one of the better years, with fewer drop-off on that. And the other piece that we'll see here is we want to start giving you a better window into the available workforce, if you will. So a new segment on total available licensed, which includes not only Oregon licenses, but anyone who's been issued a compact privilege to practice in the state. Now, there's a small population of folks who might in this moment hold both a compact privilege and an Oregon license because they may have gotten a compact privilege and then decided to stay in Oregon, and so they then applied for licensure, or vice versa on that, where they are transitioning back over. But what you can see here is that compact privileges are starting to make up 7 to 8% of the total available workforce in Oregon. This is an important consideration, particularly when we look at the results of the Oregon Health Authority Workforce Survey, which is tied only to license renewals. It does not capture information for compact privilege holders, which means when they produce their results next year that are inclusive of our renewals that show geographic distribution and FTE and clinical practice, those will be underrepresented by this roughly 7 to 8%. And with that, we have the standard data on application trends and compact, which is trending on the trend line. You see the continued growth, part of that being driven as more compact states come online. And the aging and opening of cases on the last page. I will also note that approval of this executive director's report authorizes the statutory extension of investigation period for case reporting under ORS 676.165, which extends it for another 120 days based on the dates of the meeting. And part of that has to do with when a board meets every other month, right, and the ability to carry the extension over until the next available meeting. So with that, Madam Chair, I will pause, and then if just put the financials up on the page. If there are any questions or concerns or corrections on any of the consent agenda materials.
Thank you. Do we have any questions? Is there a motion to approve the consent agenda items?
Madam Chair, I move to approve the consent agenda items as written.
Motion carries.
Madam Chair, just a point of procedure. We'll need a second, and then
Ah.
because we're on video, we should probably do a roll call vote so that we
Thank
can
you.
have that in the record. Was there someone 4 seconds?
I'll second it. This is Sandra.
Okay, and then I will do a roll call vote. Timothy,
Approve.
Aaron,
Aye.
Sandra,
Yes.
Michael,
Aye.
Susan.
Aye.
Okay, all members present have voted. The motion would carry unanimously.
Thank you.
Thank you. Madam Chair, there are still, let me double check. There are still no members of the public present for public comment. Proceeding on the agenda, we have delegate reports for the FSBPT, the Federation of State Boards of Physical Therapy, and the PTCC, or the Physical Therapy Compact Commission. There are just a couple of general highlights on the Compact Commission. They are currently in open rulemaking for their organization. We're going to go into that in detail in the discussion items. And then other than that, I know there are folks that are on a couple of the committee subcommittees for the PTCC. So if there were any specific updates that anyone wanted to give.
This is Sherry. I could start with Aaron and I both serve on the compliance committee for the PT Compact Commission. And at our last meeting, we just had a discussion a little bit about how they're going to start cracking down some more on states that aren't in compliance with some of the elements that are required to be a compact state. We've always, when I say we, I mean the staff who works for the commission through the committee have sort of said, hey, you're not in compliance with this, or hey, we need you to catch up to this, or, what are you doing? What can we do to help you? But that's been it. And now I think they're at the point where they're starting to tell states, like, if you're not in compliance by this date, we may have to start taking some action towards removing you from the compact. That's nothing that's ever actually been done, but maybe just a little bit more strongly working with some states to get them into compliance. Most of the states that aren't in compliance are usually like IT related issues or staffing issues, not people that don't want to be in compliance, but trying to really help them get there. And if they can't, what do we need to do, and giving a timeline of how they can get there.
Great summary. Thank you, Sherry.
I can also give an update on the committee that I'm on. I am on the Education and Outreach Committee. Previously, it was the Marketing Committee, which I was also on about 2 years back, and then I took a break. And so thinking about it through that lens, education and outreach for this committee and for the PT Compact is a little bit different than how we think about it, as Michelle discussed in the executive director's report. It's a lot of really kind of getting the word out there about what the compact is and how it operates, and really kind of informing existing licensees about their options under the compact. And as part of that, one of the big drivers in a recent meeting just about 2 weeks ago was really informing you all, the board members, about what the current status of the compact is within your state, and what that looks like as a piece of the pie, right, for the entire compact. And so as part of that, we're looking at generating quarterly reports. That's something that I'm very excited about, that would be able to give you guys more consistent and regular snapshots of the current status, right? So how many active compact members do we have? Essentially, the stuff that Michelle has been doing for years, that a lot of states are not getting. And so we are looking forward to that. We're also going to be pushing for trying to get more data out of those existing compact members so that we can look at some of the motivating factors and look at how does that impact how we talk about the compact, and how we communicate to licensees how it could be a benefit to them. So we'll be meeting again in the fall after some staff return to office. But yeah.
On the Federation side, a couple of highlights, and then we can do the same thing with the delegates and committee members. The regulatory training event that we mentioned in the March meeting occurred, and we did have a couple of members. So I wanted to leave space for Sandra. I didn't know if you wanted to make any comments on how you felt the training went.
Sure. Right now? It's excellent, and I hope every new member gets to go at some point, because it gives such a nice overview. There were a couple things that I thought about that came up during this that I thought were interesting that maybe we want to look at as a board at some point, maybe like when we're doing some strategic planning. But there was a really good video offered for about implicit bias, and I think everybody can go in there and watch it. It's on the Federation site. But there was some really interesting conversations about that, and of course, one thing that I'm always shocked about is how different it is in every state. Just the whole setup can be quite different. But implicit bias, some states are like not even looking at licensees' names, because we have so much bias about that. That kind of blew my mind. I'm not necessarily suggesting we do that. I just wanted to throw it out there that for everybody to have a chance to kind of think about things like that, and how people are dealing with that. So I thought I couldn't deal with any more numbers and trying to put behavior patterns and personal things with a number, but some states feel like it's really helpful to do that, and then some states are just like so different where they're not even open to the idea or may have members that aren't open to the idea of even thinking about that you have biases. So very different. It was a great really informative, really energizing. Hope everybody gets to go.
Thank you, Sandra. I was also able to attend, and it is, I think between the virtual and the in-person, I think it's my fourth one that I've had the opportunity to attend. And even so, it's such a strong benefit to be able to be in the room with a group of individuals from all other jurisdictions, and share some things, both the states that are quite different from us and then the ones that are essentially our neighbors on the different borders. So would also put in a plug for doing that. And I think we had a couple of other members that were able to attend at least parts of the virtual training. If anyone else had any comments or highlights from that.
I was able to attend. I guess I'm not a member of staff, but I was able to attend, and yeah, I would agree with Sandra. I would say that as someone who's worked for the board for 5 years now, I think, I still learned new things. and it was my first time attending. And I attended virtually, and I would strongly encourage all of the board members and staff to attend. It was great. It some of it felt like a refresher, and other pieces dove a little bit deeper and gave me more things to think about. Things like involving the legislature, reaching out to legislators to update them about what we're doing, and really looking at it through the lens of how we can be a resource, how we can, I believe the word was compassionate, perhaps, and really think about how we can regulate for public safety.
Thank you, Sarah. For other Federation committees, I can give a brief update. I am the board liaison to the Continuing Competence Committee for the Federation, and part of the work that they're doing is further developing the self-assessment tool for healthy practice that they had previewed some last year. They are working with an outside vendor to take the tool, develop it into an online app, if you will. They did make the decision to make it anonymous, which means that they won't have the ability to track or capture some of the same demographic and utilization information that some such tools could capture. But they felt that it was more important to encourage use, and the fact that it can be an anonymous tool was felt to be a stronger means of making sure that people used it, and that would better support healthy practice. They are targeting having that available by October, or I guess November, by the annual meeting. And they're also exploring ways to frame it in such a way that there would be certificates and hours that are recorded so that a jurisdiction could choose to grant continuing competence credit. So as that work evolves, that could be something that you as the board could consider how that would fit in, and whether that would qualify for credit for continuing competency. With that, I'll turn it over to others from other committees.
See, Michelle, I can jump in. I'm Michael Rennick, and I represent this board on the Workforce Committee. The focus of the committee is development of the physical therapy cross-professional minimum data set. And so it's basically the workforce questions. Sarah was kind enough to download a PDF of the survey and the questions from the survey, which I did share with the committee, as they have gotten other examples from other states as well. But it's the important, but maybe not riveting work of making sure that each data element, there's a consensus about each data element and how things are worded. So there's one common standard, and that's the goal, to have something ready by this summer. We've met, I think, about 3 times. And I'm not exactly sure if we'll have something ready. This is June, and I think June was our target. So thanks.
Thank you, Michael.
I could go next. I am chairing the Sexual Boundaries Committee, and that committee is working on a lot of really cool things. We've done some educational infographics for boards, for patients, and for licensees. That's what we worked on last year. This year, our focus is going to be educators and students, and trying to create some modules and some videos that we would have available for students and educators and boards to be able to work on decreasing the incidence of sexual boundary complaints. I also wanted to add that Michelle mentioned in the beginning, I did a couple of presentations this year was lucky to work with Catherine Caldecott from PBI and do some presentations on trauma-informed investigations and trauma-informed regulation. During one of those presentations, I was able to present at the Federation State Medical Boards Conference. And the whole general theme of that conference was trauma-informed compassionate regulation. They called the title of the conference was The Science of Sound Decision Making. And there were some really, really great presentations that I'm hoping maybe in next meeting or two I can share in a little more detail with the board. But I felt really lucky to be able to attend that. And yeah, so I'm really proud of this committee. We're doing a lot of really good work that I think our board thinks is important and is working on here in our state as well, which is great.
Thanks, Sherry. Any other highlights or? The next pieces relate to the NPTE or the National Physical Therapy exams. Of course, the NPTE is the exam provider that is selected under the board's statutory authority for the clinical examination. A couple of things that they've done to benefit test takers is they've changed the process for registering for and being qualified to sit for the exam. Before, the systems would require at least a day for the data information about qualification to be transferred to the right system so that they could then register. That is now a real-time connection. So as soon as they are approved to sit for the exam, they can schedule that test, which will really help when there are places that their preferred places they would like to test to make sure that they get seats, or for the folks that may wait until toward the end of the process, they have a little more wiggle room to do so. The second piece is the board of directors did decide not to raise exam fees through at least all of 2027, which would mean 2028 may be the first year that there could potentially be an increase in the NPTE exam fee itself. The Prometric, the separate provider where exams are held, has increased their fees starting in 2025 by approximately $10 or $12, depending on which exam and which location. So for exam applicants, that they will see a net increase of about $10 to $12 in 2025. But no increase to the exam fee itself for the NPTE. On the next piece of it, I did want to do a shout out to our very own Sherry Peru, who is the recipient of the Richard McDougall Long-Term Service Award from the Federation. And to give you some context on this, this is the history of the award since its inception. Sherry, of course, joins a couple of other folks from Oregon. And as for those of you that like to systematically go through in a competitive way to determine which jurisdiction has had the most recipients, we are tied now for first place. So just a huge shout out to Sherry, and it's great to see the Federation recognize the exemplary work that she has been doing over and over again through the years. So thank you, Sherry. And she will be honored at the annual meeting in October. That is that segment for the awards luncheon. And the speech that she gets to give will be broadcast. So even if you're not attending the annual meeting, you will have the opportunity to watch and cheer on Sherry. So just a shout out there.
Thank you, Michelle. what I'm really excited about is when you win the Richard McDougall Award, not only do you get some weird piece of jewelry or something that goes on your neck,
A medal.
it looks like a WWE belt or something. You get to attend the annual meeting on the Federation's dime for the rest of your life, I guess. And I have reached out to both Jim and Nancy Kirsch, both my two mentors professionally, and they both will be there. So I'm really excited about that. And I just to say, I'm very excited because when I look at this list of people, I see a whole bunch of people that have served on the board, people who have done really wonderful things for the Federation. And I just feel honored to be recognized as, for lack of a better word, one of the little people who's just have done a whole bunch of things, but I haven't been a board member. I haven't, served a very huge role in the Federation, one big role, just a lot of little roles. So I'm glad for all of us that do that work to be recognized.
Oh, Michael.
Yeah, congratulations, Sherry. You do a ton of service for the Federation and for Oregon. But what really touches me is how you do your work, and you're a role model for all of us in really thoughtful listening and kindness and compassion and protection and how we get that across. So just know we all owe you a debt of gratitude, and I couldn't be happier for you.
No, thank you, Michael.
And I agree. I consider you the jack of all trades for the Federation, and this is so well deserved, and congratulations.
Thank you.
Next, we also have a new board member that was just appointed through the Senate confirmation process, Timothy Brinker, as one of the PT professional members. And would you mind doing an introduction?
Sure. Thanks. It's exciting to help our profession as well as our communities that we live and work around. I've practiced physical therapy for 30 plus years, primarily in the outpatient setting, and I have multiple postgraduate certifications and fellowships to help our community as well as our profession and my patients. Outside of that, I have a few different leadership roles. I serve on the board of Therapeutic Associates. I'm a finance committee member for the American Academy of Orthopedic Physical Therapy, and I'm also on the advisory council for the College of Health Professions at Pacific University. I hope I can provide a nice bridge between clinical and leadership to help our community and our board.
Thank you and welcome.
Thank you.
The next item I wanted to highlight, even though it's not on the agenda, we were, as noted in March, originally going to be focused on strategic planning and developing the next 5-year plan. Because a number of members were not available for today's meeting, we did defer this topic and updates on this until the next meeting. And that takes us to roundtable. If there's any other items from members or committees or delegates. Not seeing any. The next item then, our first discussion item is to highlight the SCRA federal military licensure portability. This is a change that came out last year, and it provides streamlining or opportunities for active military service members and their spouses that have orders that move them into a different state, that are licensed professionals, to be able to use their license, their active license in good standing, in the jurisdiction that they're being moved to on their orders. This has been in legal review to determine how it overlaps with a state law, and particularly as you know, Oregon has a temp permit specifically for military spouses already on the books. But the pages that you have here and that are linked through the public meeting agenda, this is a fact sheet that the US DOJ has put together about how it works. But on this section, that they've been moved to another location, they provide a copy of military orders, that they have an actively used license or certificate in another piece. So that's one of the first tests. Is it's not simply being licensed, but there is sort of a threshold here for have been practicing, right? That they remain in good standing. And then under number 5, there's a piece here that they have to submit to the licensing authority of the destination jurisdiction for purposes of standards of practice, discipline, and fulfillment of any continuing competence requirements. So here, the sort of 2 limits that this would have would be demonstrating the active, beyond demonstrating the active orders, that they've been actively using the license or a practice requirement. And then this last piece is that of our standard application requirements, it would only be the educational pieces, so arguably the JAM, or potentially require that they would take the pain management and the cultural competency requirements in Oregon. So those pieces we could do, fingerprinting, other pieces of the application, and direct fees, application fees are not something that could be imposed on this. So if they come in this way, it becomes more of a registration. We review that they meet the criteria, and then they would have that endorsement or that practice privilege in Oregon separate from a license. We could set up a permit or a license, or we could call it whatever the mechanism needs to be. And that's part of what needs to be worked out about from our processes and in our system. How best do we track and process these types of applications? For us, as one of the few health professions that currently participating in a compact, the other piece, pardon me, that this says is that if they are using or they're coming from a jurisdiction or a state that is participating in the compact, then they don't have this option. They have to get a compact privilege, or of course they could apply for Oregon licensure. But if they're coming from a state that's not yet part of the compact, then it would go through this process. So it just adds one more sort of, I think of it as a pachinko machine, right? The buckets that it goes through, where we will have to design a pathway to let folks know what their options are. Coming in through compact privilege, coming in under the SCRA, they could still utilize our military temp permit, or of course they could apply for an Oregon license, and working with them to do that. So for today, we just wanted to make sure that board members had visibility into this. And what we will be doing is working to develop some drafts of rules, talking to some of the other health boards in Oregon and other PT boards and what they've done, so we can bring back to you some rules to address this. At the same time, because we're about to start the system migration, we'll simultaneously be looking at the best way to codify this into the licensing system. And because we need to start both of those processes in parallel. And then most immediately, what we'll do is make sure that we get up on the website some language about this. And frankly, we do get very few, because there are very few placements into Oregon with military orders. But we would update our language so that folks know they have this option and that in the meantime, they can reach out to us and we will help them decide. And if they want to set this up, we would do it essentially manually for now. So with that, I'll pause, Madam Chair, and happy to answer any questions or if the board has any other direction they'd like to give us as we move forward with this. Michael?
Yeah, I think, as we think about the rules, I just kind of think about the public protection. And then, part of this is that we're still responsible to enforce that. And so in the event someone with a practice privilege or a registration permission to be in Oregon had an event, we would follow our same processes, and then we would still have the authority to impact that. Is that correct understanding? Even though it's not a license or a compact.
Yeah, absolutely. And that in number 5 and this concept of submitting to the authority for scope of practice and discipline, even without an Oregon license, somewhat similar to a compact privilege, they're required to follow Oregon law. And they are subject to all of the investigative and disciplinary processes that are tied to that. So they would have to comply, even if they're the license that they're operating on. So dry needling is an example because many states have that. Oregon does not currently. They would not be able to do the things under their license that enables them to come into Oregon. They would still have to limit their practice to what complies with Oregon law.
And then maybe just to follow up, like redirect me if I'm really off base, but there are things that in the military physical therapists can do that they cannot do in public practice, at least in Oregon and most states. So that might be contemplated in the rule formation.
Yeah, I think that that similar to what we have now when folks work at the VA, and that practice, and that if they're off VA, if you will, they're required to comply with Oregon law.
Got it. Okay, thank you.
Okay. Not seeing other questions. Okay to proceed to the next item?
Yes, thank you.
Okay. Okay, on this one, we're going to shift gears to OAR 848-005-0015, which is board member compensation. And on this, we have a summary document, a background document, talking about the board member compensation. Pardon me. This is a result of House Bill 2992 from 2021 legislative session that went into effect in 2022 that made some changes to a common statute, ORS 292-495, that related to how board member compensation worked. Now, at the time in 2021, because this board is a semi-independent agency with some exemptions under ORS 182 from all of ORS 292, this gets a little circular. At that time, we received some recommendations that 292 would not apply because they fell under the exemption for semi-independent agencies. But when the Department of Administrative Services and got some legal advice for 2992 in general for all agencies, they've recently come with a recommendation for how all agencies need to apply it. And in that, a deeper look into the relationship between 182 which is the semi-independent statute, and 292, given our core statute of ORS 688, was that in fact we do need to comply with ORS 292.495 as it is on the books. So what that means is our rule that was put in place in 2021 is in conflict with the statute. The key conflicts I've outlined here, one of the first pieces is that the minimum stipend that was previously noted in that statute, which was only $30, is now equivalent to the standard federal per diem for Oregon. Our rate is below that threshold. We had the statutory authority previously to have a rate that exceeds, we still do technically, we can exceed the statewide minimum. And when we established the current $150, that was well above the $30 minimum. Now, the current total standard GSA for Oregon is $166. And so PTs, it falls below that minimum. The other clarification in the advice that Department of Administrative Services passed on is that whereas when you read our rule, it was segmented for the work in a half day and a whole day period, so more than 4 hours, less than 4 hours. The interpretation is that the standard rate of pay needs to be the stipend for that day, as long as it's above sort of a de minimis amount of work, roughly like that 15-minute mark. If you are engaged in business for the board, more than that, then you receive the stipend for that day. The other piece that is just not clear, so not so much a conflict, but not explicit, is that 292 includes description of what they call a qualified board member and a non-qualified, and that's not general qualifications, to be clear, that's qualifications for stipend. And a qualified member, it has to do with income level. And essentially what the law is trying to do is that folks that are serving as board members that are below an income threshold are guaranteed the stipend if they want to accept it. Non-qualified members, the board, based on budgetary limitations, can not pay board members stipends. So all of you at some point went through, or in Timothy's case, are about to do a self-attestation form related to that qual, non-qual. That gets documented, and that determines only should the board have financial constraints. Anybody who's qualified would still receive the stipend. Other members could receive it not at all, or some reduced portion of it. So with a lot of numbers, that's the background on why we're bringing this rule back to you. I'll talk through the recommendation and then I'll pause and can go back to any piece of this. But we do recommend that you adopt a temporary rule to bring the board into compliance with the statute, and then simultaneously initiate the public process to consider the adoption of a permanent rule. Or the other pathway is you could adopt a temporary rule to repeal the existing rule entirely. It would go off the books and you would default back to the statute. Just to remove it from being in conflict, you would still, if you took that pathway, need to initiate the public rulemaking process, which might result in language like this. But that's more if you are comfortable with what staff is recommending could be the temporary rule. You could go that route just to remove the immediate conflict. Either way, you end up in a permanent rulemaking piece. So I'll scroll just a little bit further, split the page here so you can see the change would be to remove the reference to the 150 and just make it a stipend consistent with the statute. The reason we do it that way, rather than put a more readable or a more user-friendly actual dollar amount, is that the federal stipend changes at least every year, but could change at any point based on inflation or anything else. So if we put the hard number in the rule, then every time it changed, we would have to go through rulemaking. So this would just reference back to that legislative per diem language that's in the statute. We would need to remove the references that are in the strikeout as far as a half-day, whole day. And then the other changes that are in section 2 are just some clarifications on feedback that we've received since 2021 about in the A, for example, that it's not just that a meeting is scheduled, but that you attend the meeting, and putting that language in. And the same with C, that it's not any time you testify before the legislature, because as a citizen, as an individual, irrespective of your role on the board, you can testify at the legislature anytime you wish to do so. If you're there representing the board is when doing so would qualify for stipend. And the other piece that we are clarifying is we had talked about making clear that reading the board packet materials in preparation for the meeting is board business. What this does in the language changes is before you received a half day, and then if you weren't able to attend the meeting, you didn't receive this. With the statute, it's just clarifying, if you read it, you get paid for it, right? At the full day rate, not the half day rate. So with that, the rest of the document are just references to some of the original language and links from the statutes, but I can roll it back here and pause and address any kind of questions or discussions. Michael.
I seem to be full of questions today. I assume you can decline this, and we don't have to state why. Like for me, I don't receive a stipend because of my employer has funding from the state and it's considered service. So
yes, that's an excellent question, Michael. And to highlight on this, the stipends are absolutely optional. In Michael references employer, if you are a public employee and serving on a board, you are non-qualified for receiving a stipend, so that's a non-starter. And then irrespective of whether your income level would qualify for the definition of a qualified employee, you as board members are never obligated to receive a stipend. And many folks choose not to because, you know, it may have consequences. It is something that has been brought up by many boards, is that the statute may have an unintended consequence of causing more harm than good for individuals for which the law was designed, which was to support folks that may not be able to afford the time off or the travel related with serving on a board. So it was a mechanism of a guaranteed minimum amount that could help support that. The issue is that for some folks that may be receiving benefits for which additional income could be problematic, that if they were to accept the stipend, it could actually do more harm in removing them from qualification for other benefits. So the problem hasn't been completely solved in what the legislature was attempting to do, so they may come back and do that. But long answer to Michael's question is that no, board members are not required to accept the stipends. And all you need to do, you can say that on the forum, or of course, for this specific board, you can let us know and we can adjust that. Any other questions or thoughts on this?
If there are no other thoughts or questions, Madam Chair, I move to adopt the proposed temporary amendments to OAR 848-005-0015 as written and direct the staff to initiate the permanent rulemaking process for the same.
Thank you. Any seconds?
I'll second.
I'll take a roll call vote. Timothy,
Approve.
Aaron,
Aye.
Sandra,
Aye.
Michael,
Aye.
Susan.
Aye.
Madam Chair, 5 ayes, the motion carries unanimously.
Thank you.
Okay to proceed?
Yeah, I think so.
Okay. The next review is the proposed PTCC, which is the Physical Therapy Compact Commission rule changes. Just want to underscore that the document that we'll be looking at next is not our rule, not Oregon rule, but the rules for the PTCC itself that they have proposed, and they are seeking public comment. So the documents that are in your packets and that we'll be looking at next is what they've published. And in this case, the board and your discussion and your input is what, if you would like to direct public comment to the commission, we would take that forward and present that feedback to them. Once they complete their rulemaking process, of course, and if they were to adopt a change to the rule, once that's completed, that would need to come back to you for consideration and start your rulemaking process for adoption of their rule into your rule or into 848. So the document that you have before you that talked about the changes in the summary on that, I am going to move us down. Watch your eyes. And here they've done a couple of things. I'll probably scroll down to here a little bit more. One of the first things they've done is added a definition for expired. This is something that's come up in part because different jurisdictions use the term, and we are one of them, expired and lapsed and non-renewed. There's different terminology that you find across the country. And so this definition is attempting to clarify how that works and what that means. And the other difference here is compact privileges have when you purchase one, it then comes with whatever the expiration date is on the license that you're using for qualification at that time. Some states have grace periods that you can lapse and then unlapse, if you will, after a certain amount of time. But this is clarifying that expiration date on the compact privilege doesn't extend, that's in fact a hard date. The other piece that comes in here is there was some confusion of the way language was written. It implied through the expiration date of your home license, but didn't clarify up to its renewal date that if you renew it, it's not an automatic renewal, which was some confusion for compact privilege holders, thinking it was a one-time compact privilege buy. And if they just kept renewing their home qualifying license, they were okay, which wasn't the case. So that's one of the reasons that this definition has been added. Anyone have any like questions or comments or feedback that we want to send to PTCC on this change?
I'm curious if Gayla has any comment just about the things we see of people who expire because and then have to get a new privilege. It's not a renewal, like it expires and then they have to get a new one. It seems to happen a lot.
Yeah, I don't really in regards to this particular line item. I'm hoping that will explain it a little bit more.
Okay, I'll move to the next
Thanks.
one, but I can come back to this one as well. And I think I can actually do that. The second piece that they've added is a definition for what they're framing as, and I'm going to move the screen a little bit more, significant investigatory information. Means investigative information that a license board, after an inquiry or investigation that includes notification and an opportunity for a license to respond, if required, has reason to believe is not groundless and, if proved true, would indicate more than a minor infraction. Or investigative information that indicates essentially that they're an immediate threat to public health and safety, irrespective of whether that's been determined through the legal process in the state. My understanding, and Sherry and Aaron may be able to speak to this because I think this came out of the compliance committee that was discussed earlier, that some jurisdictions are having difficulty meeting the threshold now, which is any and all investigations need to be reported. And trying to reduce that to a smaller population of things that are more critical. So said differently, that the Compact Commission or other jurisdictions in the Compact may not care if it's like a lapse and sliced for a day and there was no practice, or continuing competence hours were not completed, but are more interested in being aware of ongoing or newly initiated investigations that are more substantive.
Yeah, Michelle, I can add a little bit. First of all, our committee didn't come up with this at all. It was just kind of told to us that this was the rule, that the change was going to happen. But what I can say is what I'm learning through this committee and also from like the webinars and things that I've been doing is that a lot of states don't consider some things an investigation until they go to a different phase or a different department or something like that. So they may not even open an investigation on some of these cases. They don't give it a case number. They wouldn't even call some of these cases like you described investigations. So I'm concerned about this rule because I think it gives a lot of objectivity to people to look and be like, well, what do we call, what is significant and what is more than a minor infraction and those kind of things. I'm afraid that some states will just be like, oh yeah, that's minor, no matter what it is. So if people are moving around the country and getting compact privileges and not being marked off as being under investigation for what one state considers minor but another state wouldn't, that concerns me. But so I think they're getting stuck on we don't open an investigation on this case, so we're not going to mark it as under investigation because we don't send it to the formal investigation committee, or we don't pass it on to the next department of our state that does this kind of work. So I think that's where this is coming from, but I'm not sure that I agree with it.
Thank you, Sherry.
Yeah, I would agree. I think ultimately they were trying to maybe define what a minor infraction was, but we're not still sure.
Even in our committee, it was hard for the committee members.
Yeah.
We were asking like, well, what is a minor? And some people were like, well, what if it's just a CE thing? And other people were like, well, what if you just didn't do your documentation, or what if it's something that gets, it's going to close like ahead of time? Like, well, how do you know it's going to close without somebody reviewing it?
Yeah.
I think just so many states have different processes of how they investigate a complaint, that I think that's what the problem is.
Yeah.
One of the other questions that I wasn't sure is in this highlighted section, that after the investigation that includes notification or notice and an opportunity for the license to respond, that could potentially be interpreted here, notification as our notice of proposed disciplinary action, and then hearing or response to the notice or settlement, which would put it much further out in the process than it currently is for us. I know you could also read it just within the investigative place when we initially reach out to a respondent when there has been a complaint and they have an ability to provide their input or their do a witness respondent interview. But I'm not sure why they added that information, and I'm concerned that it could make it more difficult for us to actually report investigations if because of the use of the language notification and response, that for us that could mean the notice, which is a public document anyway, and then after a hearing.
I do know that there are some states who are having issues with complying because they have statutes or have been told by legal counsel that they cannot report investigations because they're just not allowed to do that. So I don't know if that piece would make it different. I'm not sure, but there's several states that are like, it doesn't matter what we say, our statutes or our AAG says we can't do that. But there's states that joined the compact, and they knew that that was a requirement when they joined the compact.
Well, and also the language that they adopted in their statutes to participate in the compact, it says
exactly
that you're allowed to and you're required to share investigatory information. I'll highlight a couple of the other changes, and then we can loop back and determine to what extent, like what we want to present in summary formally to the PTCC. Here's a little more amendment. We were looking at the definition with regard to expiration. These red changes are in the rule itself that references expiration. And there's a little bit more clarification in here. What we looked at before was the definition for expiration date to tie it into lapsing and re-renewal. But this is the clarifying language about how it expires, when it expires, and to provide the clarity that I referenced earlier. Then I'll bring us forward kind of a related piece to that. Currently, if somebody moves residence, so if they have a compact privilege qualifying on a home state of Texas, but they then move to Oregon, for example, another compact state, so their residence is now in Oregon, they have 60 days up from 30 days to report, or that's sort of their buffer window for making that notice. It gives them a little bit more time to go through the change of residency process. And I think the last almost to the last in Rule 3.5, it's continuing with more clarification that relates to expiration. And I believe that some of these are based on feedback that this board had provided, particularly some of these pieces in here, based on questions that have come up in the past on exactly how things expire, when they expire, and when folks are moving around. Then in Rule 6.7, the last piece is where they're applying that definition of significant investigative information. Before, it used to be all investigative information, but they've done two things. They've added the word significant in order to tie it to that new definition. But then they also added this phrase into the language itself. That is an offense of action. Which seems to then set the bar that it has to be significant or not a minor infraction, but also an offensive action, which I'm not sure what that means. If it's they had to physically do something such as patient harm, and that documentation issues when it, so I'm not sure. So with that scrolled forward, any questions, comments, or concerns that you would like us to bring back to the PTCC on any of these?
Just a question on that last one, offensive action. Does that mean that that it would be an offense that the board took action on?
Maybe. Erin?
Yeah, I would just say I think it'd be great to get an example of what they think of as a minor infraction. But I can tell you just from being on the compact committee, I mean, a lot of the states are not in compliance with this. So having more detail what a state is required to do, I think would be really beneficial for every state.
Okay. Michael?
Yeah, I just echo the previous discussion about significant. It seems like either you're in compliance with the law or you're not in compliance with the law. And then I have an ignorant question on my part. So compact privilege holders need to take the Oregon JAM, correct?
Yes.
And so do compact privilege holders need to be accountable to the laws in the states that they're practicing?
Yes.
So I mean, this reads of that member state statute or regulations. It sounds like their home state, but the compact is designed for portability of license, but you still need to meet the law of every state you're in, right?
Yeah, I think the reference there of that member's state, the member they're referring to there is the state, not the compact privilege holder.
Oh, okay. Thank you.
Absolutely.
Michelle, one thing I wanted to add about the investigation, reporting the investigations, is that it is a little bit difficult because, like, let's say one state goes in and reports, flags somebody as under investigation, and we get a report of that. At least when we talked about in the compliance committee, other states don't really do anything with that, right? It's like, oh, they're under investigation, but until there's action or something, that's part of the argument that states have. It's like, well, what am I going to do with that information that someone's under investigation? I'm going to probably let the state that's doing the investigation finish the investigation before I do anything. The only time where it's been more than that is something that's really, really serious, but usually there's an action been taken. So I think that's the argument that states are having. It's like, well, I find out that someone's under investigation in another state, then so what? like what am I going to do with that information here in this state until, that investigation can take a really long time. I mean, even here, we don't announce that someone's under investigation of our own licensees until it's something's finished. So I think that's the argument that people have. It's like, well, why do we need that information if the case isn't done yet?
Sherry, and then we'll do, I have some information on that from prior discussions, and then Tim and then Sandra. The argument has been because the compact allows for portability much more quickly than an application for licensure, that when it gives you the ability to know if there is an ongoing investigation, both for that compact privilege holder, but also as more states join the compact, that's going into the licensure system. So it may be useful if you have a new applicant to your state as well. And not that it would be grounds, because there hasn't been a conclusion yet or a disciplinary action yet, but there could be some situations where before the board would want to hand over a new license, if you knew that there was an active investigation into multiple complaints of sexual misconduct, for example, and that you would want to have a conversation, you may choose to learn more about that before you made a final decision to issue the license.
Yeah, that makes total sense. It's just hard with the compact because the person's they're already there, right?
Yeah.
And we don't have a choice of them getting a compact privilege, but for applicants, yeah, it's great to have that information.
And I think where it becomes more powerful or more useful is as more folks come online, because it could be maybe the individual is from Virginia and they have an Oregon compact privilege. You flag them under investigation, but they also happen to hold a license in another compact state that is inactive, let's say Texas. All the compact member states where that person has a license or had a license would get notice that there's a new investigation. So you won't necessarily act on it, but then Texas would know, hey, this individual has been flagged. So if the individual now leaves Oregon and tries to go back to Texas, you have that information. So it helps downstream, which was the theory of why you would want to report things. Tim and then Sandra. Timothy.
Yeah, thanks. I just want to make sure I understand the compact privileges. So if I look at our previous numbers from earlier in discussion today, it looks like we have about 490 clinicians practicing in the state of Oregon with compact privileges. So they have state licenses in other states, but they have a compact that allows them to practice in our state. Is that correct?
Yes, it's they have the privilege or the right to practice in Oregon. They may or may not actively be in Oregon practicing. Do
we know how many clinicians are licensed in the state of Oregon but practice in other states under the compact?
That information is available. We don't have it today.
Okay. All right. Thanks. I just trying to catch up on the information in regards to how important this is for our residents. Thank you.
And Sandra.
A couple of things. Rich Wolf gave actually a presentation on why this is important. I'm trying to remember the details, so Michelle, hop in if you can remember them. But they had an actual case where in the Washington D.C. metro area, there was a practitioner that did a pretty serious assault. I think it was an assault basically on a patient, and then hopped across the state line and did it again, before anything caught up with them. And I think that it's really valid. And that's kind of one of the big benefits of having the whole compact is to protect the public from people that are that are actually predators, I guess, and moving around in that really, really serious category of practitioners, I guess. And I get that it might be hard for some states that signed on. I mean, I think this is one of the big strengths of the compact is this kind of a database that will at least allow a flag. So if we get a complaint about somebody that's practicing on a compact, you know, we would maybe even just triage it to the top of the pile if we see that they're also under investigation from another state. So I think it's just really important for that national, the national safety net kind of thing to do it. And so I would encourage the compact to help states find a way to bring them up to standard without dumbing it down for everybody. That's kind of my initial reaction on this today. Am I making sense?
Yes.
Okay.
And I'm seeing some head nods with that sentiment of, you know, maybe don't loosen the requirement, but find a different way to help folks be successful. Okay. Other comments or thoughts that you'd like us to incorporate?
Just the last thought. So, like, is then one of the root cause the delay in processing? Like, my mind is kind of going, if there is such a thing as like if we're able to identify what is a significant thing that needs immediate action, is there a mechanism to act immediately on something in Oregon?
Well, we with regard to flagging under investigation, we've been in compliance on, you know, when an investigation is opened, then we will set the flag. Where it gets to, so I guess the short answer is with regard to our practice, what this would result in would be we would have to figure out what the threshold is for minor infraction, and we would be reporting less.
Yeah.
Changes.
Yeah, I'm just again, you know, welcome input if I'm using the wrong language, but I just think of due process, and so like every complaint would have due process, wouldn't it?
Yes, every complaint absolutely has the existing due process in the different states or the different jurisdictions. All this does is, in a confidential manner, let the other compact states know when there's an investigation against a licensee or a compact privilege holder that they are connected to. It's confidential. It's just a flag. It's not even marked as disciplinary action. It's just a heads up. And it's intended to try to prevent folks from moving faster than regulatory bodies can keep up with them. To give that heads up. It doesn't obligate anyone to investigate or join in or follow up with the other state. And it absolutely doesn't take away any due process rights, or it doesn't create a disciplinary action just by flagging that there's been a complaint or that there's an investigation.
Okay, thank you. Yeah, I mean, and still, so then if we think that offensive action is actually a board action, it's after the investigation. And so those two things just still don't make sense to me. So
yeah, okay. Thank you.
Michelle, I was able to find the number of compact privilege holders with Oregon listed as their home state. For to answer Tim's question, that's 38.
That's not a lot.
It's not. And I think part of that is the factor that Oregon is more of a destination state for travelers. We historically need more temporary capacity than we have permanent residency. and it doesn't translate the other way. Oregon is not a source state to provide travelers to other states. And part of that is our total license numbers are much lower than many states, Texas, for example, North Carolina. So you tend to see your travelers or your temporary staff come from those states into Oregon to provide that roughly 20% of overage that is utilized. Thank you, Gayla. All right, so what I think in summary, what I'm hearing is that the board would like us to craft a letter for public input. I didn't hear that there were any concerns with the proposed rule changes related to expiration of license, but we would give feedback essentially that would it be okay to say that our preference would be not to see the rule change? Meaning don't loosen the rule would be our preference, but help folks be successful in other ways. But short of that, at a minimum, clarification of what a minor offense is, clarification about the offensive action, and then what is meant by notification, that those we think are too vague and will cause more issues and kind of undermine the primary purpose, which is the notification and public protection. So words to that effect. Okay. Madam Chair, that would take us to the data presentation would be the next item unless.
Yeah. Do we want a 5-minute break before we go to renewals, or do we want to keep going?
And Sarah, I think it would probably be about a 25-minute segment.
A 5 minute break would be great.
Yeah.
5-minute break?
Yeah.
Okay.
Okay, so
Yes,
the time is 10:04 and the Oregon Board of Physical Therapy is in recess for 5 minutes. See you back in 5 minutes.
Good.
All right, so the time is now 10:10 and we are back from recess.
The next item will be the data presentation on the 2024 renewals, and I will turn it over to Sarah to walk those through. And Sarah, I'll work the slides, so just let me know when you want me to advance.
Sure. Get water before I start talking for 20 minutes. Okay, so today I am just going to be talking about the 2024 renewal. A lot of this presentation is going to look similar to some of our members who were here in 2022. A lot of it's kind of literally just an update, but then because of some improvements and stuff we made, there will be some new info. So as always, when I'm giving these kind of dense data presentations, feel free to interrupt me, raise a hand, call out. I will not be offended at all. I'd love to answer your questions, and yeah, so we can go ahead and get started. So just giving you guys, and especially because this is public session, we have some new members, giving you guys kind of just rough guideposts for how renewal works for Oregon Board of Physical Therapy. We do a biannual renewal in even years, and all licenses lapse on March 31st, regardless of when someone was licensed. Their license expires on March 31st. So if that license was initially issued on March 30th, their license is good for 1 day, and then they have to renew it if they want to continue working into April. And then once a license does lapse, it can be renewed for up to 5 years before it permanently expires, and then they have to submit a completely new application, go through the full renewal process. So right now we are in that lapsed period. So anybody who didn't submit an approval submit a renewal and have it approved by April 1st, they could still continue to practice once they do submit and have a renewal approved at this point. Okay. So in 2024, We had 5,871 renewals approved within that regular renewal season. So early January through March 31st. 9 of those licensees had lapsed in 2022 or earlier. So rather than renewing during, any time of the year, 9 of those renewals that happened within that 3-month period were just kind of folks coming back, folks returning to the state or returning to work. And so those 9 did have some additional pieces that they had to complete that we won't talk about today. But stuff like retaking the ORJAM, redoing the background check. So those 9 were a little bit more labor intensive. Since April 1st, we've had 56 additional lapsed license renewals that have been approved. 3 renewals are still in a status of incomplete. Only one of those is from that 3-month regular renewal cycle. And that's because we're waiting on that licensee to complete some issues that we identified with their application. And then we did have a slightly higher number of renewals submitted this go round than we did in 2022. About 9% more, which is in line with something that many of you guys may have heard me talk about before, which is kind of the renewal drop off, where every renewal cycle, the number of active licensees increases, and then at renewal it drops off, and then the next year it increases a little bit higher, and then it drops off. So we're still seeing upward growth in the number of licensees. But we did just go through this sudden event where those numbers dipped. But overall, we are still seeing growth. You can go ahead, Michelle. And so, like I said, that there's that kind of sudden cutoff. At the March meeting, I did present this little slide that you can see in the corner, which was what we anticipated our work over the next 2 weeks to be. That orange segment in the original pie chart is what we thought we were going to do. That's the number of renewals that we were anticipating between March 15th and March 31st. We were pretty much dead on. I think we had a difference of about 51 applications. We had 51 more than we anticipated. And so, those, Michelle had mentioned in her executive director's report that, we see this kind of biannual drop. That seems to be consistent. And so it was consistent this year as well. You can head forward. So to give you an idea of what the licensees have to do in order to renew their license, I'm looking at the folks who were present, and 4 of you renewed your licenses. So this isn't going to be a surprise. But you had to confirm and update your contact information, your place of practice. We do ask if they hold any other healthcare licenses. So if they hold a license in Washington and they hadn't reported it previously, we ask that. They're not required to provide that, though. But it is good information for us to have for, if we know that someone's under investigation, or if we see that they're practicing out of state, it's good to know where else they're working. They do have to provide information on continuing competency activities. For most folks, this is going to be 24 hours of continuing competency. For folks who have been licensed for less than 15 months, they have to provide 12 hours. For folks who have been licensed less than 3 months, they don't have to provide anything. They do have to upload documentation, and I'll talk about the continuing competency piece a little bit later. They have to complete an OHA workforce data survey. I've done presentations on the results of this before. We are going to get that data later this year, hopefully. We get the raw data from OHA of what they submitted, and then that way we can dive a little bit deeper than OHA does in their published reports. But we probably won't get that until probably around the new year. And then they also have to answer what we call declaration questions. These questions are things like, have you been arrested since your last renewal? Have you been disciplined by any other board? Are you under investigation by any other board? Any sort of those things. If they answer yes to any of those questions, it gets flagged when we are processing them as staff, and it goes to Sherry for review. And then finally, they have to make payment. The act of making payment is what submits their application to us. So if they never make payment, we never look at it. You can jump forward to the next slide, Michelle. And so this is what staff does, right? So that pink slide was all of the licensee's responsibility. This is staff's responsibility. So first thing we do is confirm payment. We confirm that they completed the OHA workforce data survey. We don't care what their results are. We don't care what they answered. We just are looking for, yes, OHA got the survey, or no, OHA didn't get the survey. And whatever they answer to that, because it is demographic information, it's information on their disabilities, if they have any information on where they work, none of that has any impact on whether or not they're able to be licensed in Oregon. Then we look at those 5 declaration questions that I referenced on the last page regarding arrests or anything like that. We see, does it have a flag that they answered yes to something? If it does, it goes to Sherry for review. Then we look at those continuing competency activities. We review the certificates to see if it matches. Generally, we are not doing 100% of those, but we're looking at the table of everything that they submitted and seeing, okay, do these dates kind of line up? Are they saying that they did 26 hours in a single day? That sort of thing. Are we looking, we're looking to see, are the dates within the current certification period? Are they doing multiples? Kind of just doing an overall review of what they submitted. And then if any yellow flags come up, then we're going to do 100% on those certificates and make sure that everything looks correct. If not, we usually do a spot check of 1 or 2, check to make sure their pain management is the correct pain management course, that sort of thing. And then mark it as reviewed. If there are no issues, if there's no issues, we go ahead and approve it. The staff member would approve it. If there are any issues, we mark what those issues are directly on the renewal record, and then it gets a second set of eyes. So that might just be, hey, this, they didn't take the right course, or that might be, hey, something looks weird, and I can't really, I can't determine if it's actually weird or if this just seems strange. If it's something like, hey, do you think this should count for continuing competency? It might go to Sherry so that Sherry can review and see, I've seen other folks take this and it's a great course. Or no, maybe we should get a course syllabus on this and see if it actually applies. Okay, now you can jump forward. We made a lot of improvements since 2022 in how we handle that. A lot of those pieces are just, we're more familiar with our new licensing database. It's not new anymore, but we're more familiar with it. And so I'm going to talk a little bit about what the licensees saw as changes. Maybe they didn't clock them as changes, but they were changes to us. We updated the renewal application. We provided some additional context and gave them more helping language so that we could really help licensees answer the questions accurately, and help them know what they're supposed to submit. We also increased our communications to them through emails, targeted postcards. We created some videos, and then we did create a 7-page PDF that really dives deep on all of the continuing competency questions that we got in 2022. You can jump forward. And so some of that communication, just looking at who it reached and how many people. The videos that we published on YouTube have been viewed 1,566 times, which is small by YouTube standards, but in terms of the number of licensees that we have, it's actually pretty significant. So about, more than 10% of our licensees watched one particular video. I guess I'm assuming that they're licensees. I'm assuming that members of the public aren't just casually watching how to renew an Oregon PT license. But 766 folks watched that one video that we published in January, that's more than 10% of our licensees. And then 85% of our viewers actually watched it directly on our website. So I found that really interesting because it shows that people are going to our website as a resource. The emails that we sent out, we did targeted emails this year, which is similar to how we did it in the past, but we really kind of drilled down. Again, we're more familiar with the licensing database and how to use it. And so we were able to target folks who had not renewed yet, instead of just sending out like a blast news brief saying, hey, everybody renew. We sent out 4 of those emails. And then additionally, there was information in the news briefs. And then this year we actually returned to what we haven't done in a while, which is U.S. Postal Service, snail mail. We sent out 4,789 flyers with 1 month left in the renewal cycle to anybody who hadn't submitted a renewal application yet. So some of you guys might have gotten that. We, with all of those outreaches, we did see a bump in the number of submissions. So if you want to go to the next one. So yes, we made improvements to what we communicated to our licensees, but we also made some improvements in how we processed the renewals. The biggest change I would say is that we deferred the background check to be completed until after the renewal season. In 2022, we did a Oregon-based law enforcement data system background check on every single renewal submitted. And so we, I think, had around 120 hits. And so we were able to confirm, yes, they did report all of their arrests in Oregon. Or no, they didn't. Oh, look, now we need to have a conversation about why they were out of compliance with our laws. And so this year we decided, since we do have that benefit of 2 years ago, we did a 100% background check. We deferred that until after the renewal season this year. And so that's a return to what we were doing in 2020 and before, where we are going to wait until after renewal is done, and then everybody who renewed, we're going to send a batch. And so that way it's a little bit less manual. It takes a little bit of that work out of that heavy period. And we also have new abilities with our software vendors to really streamline that process, but that streamlining can't happen unless we do it all at once. We did add additional data points to renewal records, and so you'll see some of the output of that later, where we were able to really drill down on where are people hitting pain points, where are people having problems with the renewal. And then we used the 2022 data to plan our workload and staffing levels. In both 2022 and 2024, we did work with some temporary help, but in 2024 we were able to use less temporary help and use it later. So for a shorter period of the renewal cycle and fewer hours. And then we specialized the roles that we were doing. This really kind of allowed all of the staff to become subject matter experts in what they were doing and let us kind of click through a little bit faster. I'm sure that my colleagues can attest that when I had to work on somebody else's specialized role, I was so slow at it, but I could get through what I had to do so fast. So that really kind of streamlined things and helped things go faster. And then we also did a soft opening buffer this year where we had renewal open, but we didn't communicate that yet. That gave staff enough time to really specialize and really train and get our head back into that renewal process that we hadn't done in about 2 years. You can keep going, Michelle. And so this is gonna kind of show you how many renewal applications were submitted each day of the year in 2022 versus 2024. And you can see it's pretty comparable. The number of submissions that we got really kind of ramped up. That last month of renewal is really all hands on deck. That's all we're doing. That's all we're doing all day. And we're doing it every day of the week. It was 7 days a week for staff. I am just going to point out that you can see here on the green line, which is 2022. you see that big jump right around the 11th of January? That is when we sent out our communication last year. That's when or 2 years ago. That's when we said, hey, renewal's open. We get this huge bump. This year we delayed that a little bit longer. It didn't get sent out until the January 26th. And if you jump forward to the next slide, Michelle, I think it's a little bit easier to see why. So the orange line here is the same thing. Still that submitted. How many applications are submitted per day? But the blue line is staff input, right? So that's when we're doing the reviewing, we're doing the processing. And so you still see a jump on the 11th of January in 2024. That January 11th jump in processing is because all the way back in December, when our software vendor launched and allowed renewals to become open, there was a bug in the system, right? It was generating a date incorrectly. And so that period of holidays, back from holidays, renewal opening, that period where there's no work being done, no approvals being processed, is because we were waiting on a bug to be fixed. So you can see that the orange line is still going up. Submissions were still coming in, but we weren't processing them because we wanted to wait and make sure that the system was really working effectively. And then you see another dip in the number of applications that were processed. That is because you all were joining us in a board meeting. And so it was all hands on deck for that board meeting. And then you see another jump because board meeting's over. And now we've had time to work on it again. And then we actually waited until January 26th to send out that final message, because that's the date that the YouTube video that we published about how to process was ready. And so we wanted to wait and make sure that we were giving folks enough tools to be able to be successful in submitting that application. And that also helped us, right? Because if we are suddenly swamped with questions that the YouTube video could have answered, that helps prevent the phone calls to Gala, the emails to Gala. And so that's kind of where you see these spikes in what looks like a lot of staff work. And it is a lot of staff work, but I do want to just point out, there's not a single day throughout this entire chart that staff were not actively in the system, looking at what was being done, and potentially reviewing applications, but just not clicking approve, which is what that's tracking.
And I think, Sarah, I'll just interject here. You mentioned it on the prior slide, but it does show up really nicely when you look at this chart. Starting with the 1st of March, you can see where we went to effectively 24/7 support. That's reflected here, where prior to that in February, we still might have had weekends and evenings that weren't all renewals all the time. Yeah.
Thank you, Michelle. I would have forgotten that. I think we talked about that in the meeting and when we discussed this, and then of course I forget it in the actual meeting. All right, you can jump forward. And so looking at how long it takes for staff to process an application, this chart is only going to show you the ones that were fully complete on submission. So these are the ones where there's no issues, nobody's paying by check. We have everything we need to process the application the second it hits our system. And so for 34% of those, they were processed in under 4 hours. I think, if I recall, it's somewhere around 600 of them, which is, roughly 10%, were processed within an hour of being submitted. And so, I think some of our licensees may have thought that it was an automated system, that the software said, yep, you did everything and here it's approved. No, that was us. That was one of the 4 of us. And it was probably Michelle who was clicking, yes, everything is done. If we look a little bit further than 4 hours, 88% of renewals that were submitted and were complete on submission were approved in under 24 hours. And so, we really, really cut down that staff processing time compared to last time. Last time we know that we were taking longer we didn't have a way to really divide the complete applications versus the incomplete applications. And so I don't have like an exact number to correlate to 2022 for this, but we do know that we got faster this year, right? We streamlined the process. It touched fewer hands. And if we look at some of those, 4 days, 5 days, 6+ days, that small little under 5% of the pie chart, all of those were from our soft opening, right? Those were during our board meeting. Those were during the bugs. And so I cut out the ones that were during the bugs specifically. There might be a few that snaked in because they were submitted the same day that it was approved, that the bug was fixed. But yeah, all of those are within the first 2 weeks of January. So not even the full soft opening, right? That's all just up until the board meeting happened. And then we were able to really kind of dive deep on renewals. And like I said, this doesn't include anything where we had to reach back out to the licensee. Again, jump forward. And so looking at those ones where we did have to reach out to the licensee, this is what I was talking about, that we didn't have this tracking mechanism in 2022. We implemented as part of our review process, when we processed an application, we would say, okay, we would look at these 4 issues, right? You can see the table down in the corner. Is the issue with pain management? Is the issue that they didn't take a cultural competency course that we think applies? Is there some other continuing competence issue, like they uploaded a receipt instead of a course completion certificate, or any other issues like a payment issue, or trying to think of what some of the other issues were.
Not getting the OHA completed was one of the other issues.
Not getting what?
The OHA survey completed.
Yes, thank you. Thank you.
Yeah.
That was the other big one. If they just clicked through and didn't take the OHA survey, then we would have to do a little bit of follow-up with them on that. And so you can see 91% of our licensees had no issues whatsoever. We were able to approve them pretty quickly. This is huge for us because in 2022, we were estimating that it was about 20% of applications required additional action by both staff and licensees. So we cut that number of folks who needed follow-up in half this year.
And I think
sorry,
just to underscore that, I think that this is where you see the impact of the additional communication and outreach, the streamlining and better wayfinding in the applications, as well as the high touch training that we did to help folks successfully complete what at the time were the new mandates for the pain and the CC. That delta between the 20 and the 9% is a result of those efforts.
Yeah, definitely. Yep, you can jump to the next one. And so that processing time pie chart 2 slides ago, where I was showing that 88% of them were processed within a day. This is the reverse, right? This is the ones where we did have to reach out to the licensee, and how much time did that take? And so for all of these licensees who needed some sort of contact, we started off with an email. Hey, it looks like you took a different pain management course than the one that's required by the legislature. 10% of folks were able to make that correction and get it back to us, and we were able to approve it within 4 hours, right? So that's huge. That's one contact, right? Versus some of these folks in the dark red section, 6+ days, where they definitely got at least 1 email. They got probably a second email, potentially from a different address, depending on who was doing the follow-up. And then they got a personal phone call from Kayla Goodwin. And so this time elapsed in all of these is inclusive of their response time. So we part of the reason why we did the snail mail mailer this year is because we were hearing from licensees, oh, I didn't get your email. I had no idea. It went to my spam. I don't check my email anymore. I get so much junk, right? And so that's kind of why we did this three-tiered response. They got an email initially saying, hey, you need to correct this. A different staff member would usually go through every couple of days, go through all of the ones that we had marked as awaiting a response and do a second email. And then if it was still awaiting a response, Gayla would reach out to them directly. That time frame got a little bit shorter as it went on. You know, that last weekend of renewal, if somebody was incomplete, we were calling them potentially the same day to make sure that they didn't lapse and that they were able to work on Monday. Any questions on that before I jump forward?
Sarah, I just wanted to add, some people didn't get even answer the phone and needed to get texts. And it was really eye-opening to me of who quickly answered a text but didn't answer an email or a phone call.
Yeah, we moved to texts really kind of in that last week when we were, you know, wanting to make sure that we weren't having licensees engaging in unlicensed practice.
And again, the objective here is being motivated by wanting to help licensees successfully renew. And so that high touch, that outreach, trying everything that we could to communicate with them to have a completed renewal before there was any potential lapse in their license is what the driver was there.
Okay, moving on to kind of what I think a lot of licensees probably consider the bulk of renewal. These continuing competencies that activity completion that they need to provide proof of. And so this looks at how many activities were completed during each of these months of the 2-year, I'm blanking on the word, the continuing competency cycle. Because they could submit any continuing competency from April 1st all the way through March 31st. And so this bar graph is very similar to one that I showed in 2022. Over half of all courses and activities are completed in the last 3 months of the 2-year period. That's something that, you know, things like timing for conferences, looking at kind of what workload might look like for PTs who are doing their continuing competency. That's all information that you know, it doesn't have any impact on whether or not we approve their renewal, but it is interesting when you think about how employers might utilize that information to, you know, block out time throughout the period, or, you know, make sure that all of their employees are registered for something before March 31st, that sort of thing. Looking at the number of activities, there were more than 58,000 activities submitted. This year, we did not do a 100% check on every course completion certificate, but I do just want to point out that that is what we did in 2022. So that's part of the streamlining, right? We didn't have to look at 58,000 PDFs this year, but we did still spot check at least one for every licensee. So that being said, we definitely looked at more than 6,000. And then if we look at how many hours Oregon licensees actually spent, they spent more than 21 years doing continuing competency within the last 2 years. No breaks. So, yeah, a huge number of continuing competency activities taken. You want to jump to the next one? So one thing that I wanted to highlight is that we are on the 5-year mark between, the 5-year mark since the board created an administrative rule distinguishing clinical activities from non-clinical activities. And part of the motivating factor, and Michelle, feel free to jump in on this. Part of the motivating factor is that we knew that licensees were engaging in additional work that maybe didn't qualify as clinical continuing competency, right? So taking a course on burnout, I think we can all agree that's valuable for our licensees to engage in, but it's not necessarily clinical. And so that's where the board created these rules where folks could take anything in these 4 categories that you see in the smaller pie chart. So they could take a course on ethics and have it count. The way that these are structured is that they cannot take up more than a third of the licensee's total continuing competency. So for most licensees, that's going to be a maximum of 8 hours of non-clinical activities. And then in any one category, they can't have more than 4 hours. So a good example is all of you here. You all definitely will do more than 4 hours of committee work just by being on this board over the course of the next 2 years, but you can only apply 4 of those hours in that little gray pie chart section. And so one thing that I think is surprising is that these non-clinical hours are a tiny, tiny chunk of the pie. Another thing that is surprising is I didn't give you guys the word cloud of what all of the courses were that constituted these non-clinical hours, just because folks can freely type in whatever they want to call it, and so it becomes difficult to really kind of show what trends are without doing a lot of data cleanup. But looking at those 1,330 courses, I was really struck by the fact that some of them I would have considered clinical. Some of them were things like pain management, right? Cultural competency, things that really dealt with interacting with a patient in a clinical setting, but they were looking at it as personal development. They were looking at it as potentially becoming a better clinician. But I think we all kind of maybe would agree that some of those things are clinical skills. So that's something just to consider as we're looking at the 5-year mark and whether or not this kind of clinical versus non-clinical distinction continues to make sense. I just wanted to give you kind of the high level of how many people are taking these, how many courses are there being taken as we consider that further. Do you have anything else to add on that, Michelle?
Only that the 5-year rule review is what Sarah is referencing there, that we are required by the legislature to review all rules. And so this is one of the ones that's up for your review, and whether you wanted to make any changes to the breakout in the clinical, non-clinical distinctions or totals, or if you're still seeing the value. So when we do that, we can bring back like more detail on numbers and that for that rule discussion.
Mm-hmm. And at that point, I'm happy to give to do that data cleanup and really kind of drill down on those specific activities that folks are marking as non-clinical. But for the purposes of today, I didn't want to get too in the weeds.
Yep.
All right. And then I did want to talk about the 2 mandatory continuing competency activities. These aren't new this year. This is the second renewal cycle where everybody had to take these. The 2 pieces are changing the conversation about pain, which is a required course. There are no alternatives for that class. And that is put out by the Oregon Pain Management Commission. The other one is the cultural competency course. This one, there's a lot more flexibility about what they take. The OHA publishes a list of courses that are approved, but they don't even have to take a course that is approved. They just have to be able to show that, yes, this meets the criteria set by OHA. We maintain a list of ones that we have reviewed and have said, oh yeah, based on the course syllabus, this absolutely qualifies. We also published that OHA list, but folks can go outside of either of those lists. This was a huge pain point in 2022 because folks did not realize that these were requirements. And so I think this is really kind of one of those driving factors between that drop in issues. That 20%, I'd say 18 of the 20% was probably related to these two in 2022. This year it was a bit less. And so I think that the larger question that we got about these was folks who didn't realize that it was every renewal cycle, right? They said, oh, I already did that in 2022. I don't need to do it again. And that was part of the change, is that it used to be just at initial licensure that they had to do this. And so I think that folks were still kind of in that mindset of, oh, I've got to do this once and then I'm good. Nope, they have to do it at every renewal. And then if we look kind of at that, those two required courses, those do eat into their 24 hours, right? So there's 2.5 hours minimum that of our high of 24 hours that they take that's exclusively dedicated to these two requirements from the legislature. And so if we look at the number of courses, that huge number of 58,000, I think it was, about 21% of those are taken up by these two specific courses. And those do get categorized in that clinical bucket as well. And yeah, so it's about 20% of the courses taken are these two mandatory continuing competency activities. Interestingly, this cycle, APTA did cease offering their OHA-approved cultural competency course. If folks had already taken it within the renewal cycle, it would have still counted, but they no longer offer it. And so those cultural competency courses, there's nothing that's specifically written with a PT in mind. They are more focused towards general healthcare providers. And that is all I have on renewal for this year. Does anybody have any questions? Hoku's not here, so I know I won't get one from her. Susan.
Yeah, I mean, first of all, thank you guys so much. That's clearly a tremendous amount of work, and then putting all this together for us to see. But the 24/7 work going on, all of that is amazing. So thank you all so much. One question, so the deferred background checks, so those will get run, assume the background checks, and then is there a separate mechanism for if something is flagged on there? Like, so I assume the licenses were all approved, and so
yeah.
When do you anticipate a spike in work for that, of having to go back and revisit licensees who something shows up on that?
Sure. So just to give you a little bit of context for 2022, if something was flagged, we couldn't actually, because of due process, we couldn't actually deny their renewal, even if we saw that this licensee has been arrested 3 times and hasn't reported any of it to the board and said, no, I haven't been arrested. And in some cases, it may have gone back several years that they hadn't reported things. We still had to approve their license, and then we brought a case to the board. And so I think that was kind of a driving factor in us deferring it, right? Because we knew that it was going to create additional work, and there was no reason to create that additional work during the renewal cycle when it wouldn't impact whether or not they were able to practice. Looking at the way that we handled it in 2022, we ran a Oregon-based non-fingerprint background check. So when folks are initially licensed, they go and get fingerprinted. FBI gets those fingerprints and they send it back to the state police. We find out if they have any Oregon records, and we find out if they have any FBI records. When we run them personally without a fingerprint, we can only see Oregon records. And so, thinking about portability, the compact, how folks are working in telemedicine, we kind of really took the idea that just getting Oregon results isn't it's not accomplishing the goal that we want to achieve, right? We want to know if somebody's been arrested, whether or not they were arrested in Oregon or Washington or Idaho or New Jersey. And so we've been looking at different vendors that we could use to pull a different kind of background check. And so that's kind of where the timing is unknown right now, because what we're looking for is somebody who we could do a batch search so that I don't have to type in 6,000 social security numbers because I don't want to do that. And so we're looking at vendors who can provide that service for us. We think we've identified a few, but we're still kind of looking at what that's going to what the time frame on that's going to be. But I think we're pretty confident that it'll be done before the end of the year. And in a perfect world, it's not going to create a huge amount of work for staff. It's going to we're going to send a big batch. They're going to send it back. Maybe we'll get 200 hits, right? And then the rest of them, we don't have to manually enter as being clear, which is what we did have to do in 2022. We'll be able to work with our licensing database vendor and say, hey, create a record that's saying that they were clear on this day. And then it'll just be sorting through those 200, or that's a complete ballpark number, sorting through those records that do have a hit to look at, have they reported this, yes or no. That should be relatively quick because we already have that information in the database. And then any flags that we don't know about would then probably come to you guys. So end of the year, I guess I would say you could hope to see those, or early in 2025, you might see those at a board meeting.
And
Got it.
one
Thank
of the other contributors is that we don't want to start that process until we've completed the migration to the new licensing system. So that puts us probably not starting the checks until most likely till the fall, most likely September. We would initiate that process. And just one point of clarification on the background checks. I know that Sarah was talking about a particular data element. We don't necessarily use the social security number for the background check. That's not tied into whether folks have voluntarily allowed the use of that as an element, but it would be tied into other identifying information to run those checks. So just to clarify the record there.
Yes, sorry. In 2022, we actually used the date of birth, not the social security number. I'm just thinking about what the fields are that I could use. The search fields. Michael?
Hi, I echo Susan's thanks to you and everyone on staff. Geez whiz, that's a crazy amount of work. And thank you for the thoughtful data. Two questions. One, as we approach the 5-year review for continuing competency, should we take a step back and think about what the literature says around required continuing education and competency? Like what I know about that, and it's not new, I don't think, is that there's not much correlation between required continuing education and actual competency to practice, but it's hard to figure out measures. I don't know, is that a topic of conversation? So Aaron, are you and Sherry on the continued competency committee, or is that Michelle?
I'm the board liaison to that committee, and Michael, yes, I mean, determining the best way to assess or support continuing competence and the way that's accomplished, and that committee is providing some resources there. And yes, for your work, what I'm anticipating is that as you're talking both in the strategic planning and framing pieces, and then specifically in the continuing competence rules, that it wouldn't just be looking at this one renewal and how folks use it, but stepping back and determining, are the regulatory requirements, are the rules accomplishing what your mission is, what your objective is, and how can you make efficient or effective regulations and remove any that are having an unintended or a negative impact on that. There is, as a member of the compact, you are statutorily required to have some form of continuing education requirement. But beyond that, you have absolute control over the number, the scope, and the content of continuing education requirements here.
Great. Thank you very much. And then the second thing is just maybe more, I guess the question is, do we or does the profession have input into the required courses? I'm thinking about the pain course. I did learn things that I didn't learn the first time around. But I don't know that repeating that for the next 10 years would continue to be as valuable as it maybe was the first couple times.
We have no direct control. There is a common statute that applies to most of the health professions in Oregon. So it is the legislature that has established that requirement. What you can do as a board is provide information that you've effectively received feedback from licensees that it may not be beneficial as a requirement every single renewal period to request a change. The other thing that licensees could do is approach, if not directly to their representatives and senators, to bring that information also to the association and request that they reach out on behalf of the professionals to bring that feedback to the legislature. So sort of those three paths. But otherwise, we do not have any direct control as an agency, and you don't have the ability as the board to not require that.
Yeah, and to be clear, I was just speaking as an individual. So thank you very much.
Absolutely.
I will say that the Pain Commission meets in September. So pushing for, I absolutely hear you, Michael. I think that folks probably are, particularly like the folks who took it when they initially got licensed and then have to take it again shortly after. One thing that we might consider is pushing them to have multiple modules, right? So that you could take a different class the next time that covers similar items, but maybe with a different lens or something like that. I think there's also been talk about potentially looping it in with the cultural competency requirements. But again, all of that is outside of the jurisdiction of this board, unfortunately. Any other questions?
I just wanted to add that one thing I think would be that I saw come up a lot that I think is just going to keep on being an issue. So we need to look at it when we look at the rules. Are these required workplace competencies? Pretty much everybody is required from work to take some kind of classes. And we all had a really hard time figuring out, are these clinical? Are these not? Are these required workplace competencies? Like, for example, HIPAA versus fire safety versus company policy courses. So it was really hard to determine, like, we really tried to help people and say, okay, there's clinical stuff in this thing they have to take every year, even though it's a thing they have to take every year. So I think it would probably help us to define that a little better or look at that a little better, because I think as budgets get tighter, a lot of people are relying on these workplace things that they have to take anyway, and using, big companies like MedBridge, Relias, things like that to take the majority of their continuing ed. I did ask MedBridge to give me sort of an account that lets me audit all their classes. So at least I can go in if someone's putting in something that I'm like, what is this? Without just looking at the objectives, I can go in and actually see the course and see what the material was. But I think that's just going to keep being something that we're going to have to be on top of, because I think that was hard for all of us to sort of tease out these classes and figure out if they would count or not.
Yeah, and that's another thing that whenever we discuss that kind of 5-year review, I am hoping to kind of give you guys a better understanding of where folks are taking classes. Are they taking these, Relias, these required courses that are for their employer. But that again requires a lot of data cleanup, right? Because someone might have typed in MedBridge and another one typed in the name of the instructor and a third person typed in the name of MedBridge's president. And so yeah, it's going to take a little bit for me to look through a 58,000 cell Excel spreadsheet. And so I didn't want to lose sight of the forest for the trees in this presentation. But yeah, that can be something that we talk about at that one. And so if you do have any questions about continuing competency, or if you want to see as we prepare for those conversations, I'm not sure which board meeting we'll be discussing that at, but feel free to send me a message saying like, hey, Sarah, I thought about this when we have this discussion. Do you have any data on that you could present as part of that discussion? Because I will always take any requests. If I can get you guys the information, it's much easier for me to give you what you are asking for rather than me have to, think about what to give you.
Thank you, Sarah.
Yeah.
For the next item is just general other business or old business. What I wanted to note is, in light of board member availability, we did have to shift from an in-person meeting today as originally scheduled, and still want to find a way to do that. We will in large part because not everybody is present today, reach out offline to talk to you about schedules and availability to determine if it's possible to convert all or part of the currently planned July meetings to an in-person format, or if we would need to look more broadly to reschedule things. Looking further afield, we may also need to talk with you about the September meetings and potentially either changing the format of that or the timing of that, and take that into account based on when we might change dates on that. So just some notice that we may make some adjustments in July and September as far as members of the public watching. But for board members, we'll reach out and do some scheduling surveying to see what will work best for everyone. So we'll follow up with that after the meeting. With that, we have no other scheduled other business for this part of the meeting. So, Madam Chair, I can turn it back over to you. There are also not currently any members of the public present. But to note for the record, what would happen for anyone who does join the meeting, which they can do at any time after the board convenes into executive session. You do come into a waiting room. We would see you enter the waiting room, and we would communicate with you as far as the timing for when the board would be coming back out of executive session. So there's no one to place into executive session now, but I will monitor for folks who come into the room during the meeting and make sure they're aware of what's processing since they're not present right now.
Great. Thank you, Michelle. So the time is 11:06 and the board will now adjourn public session.
And I think, Erin, if we can have you go ahead and do the enter into executive session at this point in the recording so it stays here, and then we'll pause after that before actually going into, so that the statement to move into executive session is part of this record.
Thank you. The time is now 11:07 and we will call the meeting to order into executive session. In executive session, the board may consider information obtained as part of an investigation into conduct of licensees or applicants, consider investigatory information and reports under ORS 676.165, or consider other information or records exempt from public inspection, including advice from the board's legal counsel. Representatives of the news media and designated staff shall not be allowed to attend,
Shall be allowed.
or shall be allowed to attend. My apologies.
No worries. And with that, I will stop the public recording.
Okay, the time is now 12:59. In the Oregon Board of Physical Therapy is entering public session. For the record, all members are present that were present in the prior public session. Are there any board motions as a result of the executive session?
Madam Chair, in case number PT 834-11/23, I make a motion to close case.
I second the motion.
Tim,
I approve.
Aaron,
Aye.
Sandra,
Aye.
Michael,
I
Susan.
Aye.
For the record, the motion carries unanimously.
Madam Chair, in case number PT 851-03/24, I make a motion to close case.
and I second the motion.
Tim,
Aye.
Aaron,
Aye.
Sandra,
Aye.
Michael,
I
Susan.
Aye.
For the record, the motion carries with 5 votes.
Madam Chair, in case number PT 854-04/24, I make a motion of finding of sufficient evidence of violation of ORS 688.140 (2) (a) and OAR 848-045-0020 (2) (i) (s), and move to issue reprimand and civil penalty of $100 and offer settlement offer allowing waiver of civil penalty with completion of the OR jam.
and I second that motion.
Tim,
Aye.
Aaron,
Aye.
Sandra,
Aye.
Michael,
I
Susan.
Aye.
For the record, motion carries unanimously.
Madam Chair, in case number PT 865-04/24, I make a motion to close case.
and I second the motion.
Tim,
Aye.
Aaron,
Aye.
Sandra,
Aye.
Michael,
I
Susan.
Aye.
For the record, the motion carries unanimously.
Madam Chair, in case number PT 841-12/23, I make a motion to close case.
I second the motion.
Tim,
Aye.
Aaron,
Aye.
Sandra,
Aye.
Michael,
I
Susan.
Aye.
For the record, the motion carries unanimously.
Madam Chair, in case number PT 856-04/24, I make a motion to close case.
and I second the motion.
Tim,
Aye.
Aaron,
Aye.
Sandra,
Aye.
Michael,
I
Susan.
Aye.
For the record, the motion carries unanimously.
Madam Chair, in case number PT 857-04/24, I make a motion to issue license and close case.
And I second the motion.
Tim,
Aye.
Aaron,
Aye.
Sandra,
Aye.
Michael,
Aye.
Susan.
Aye.
For the record, the motion carries unanimously.
Madam Chair, in case number PT 864-05/24, I make a motion to issue license and close case.
And I second the motion.
Tim,
Aye.
Aaron,
Aye.
Sandra,
Aye.
Michael,
Aye.
Susan.
Aye.
For the record, the motion carries unanimously.
Madam Chair, in case numbers PT 855-04/24, PT 863-05/24, PT 866-04/24, PT 877-05/24, and PT 869-05/24, I make a motion to ratify the administrative closure of these cases pursuant to delegated authority.
I second the motion.
Tim,
Aye.
Aaron,
Aye.
Sandra,
Aye.
Michael,
Aye.
Susan.
Aye.
For the record, the motion carries unanimously.
Madam Chair, there are no more motions as a result of executive session.
Thank you, Susan.
Madam Chair, there are no additional items on today's agenda.
Michelle, can I just bring up one thing? For case number, let me find it. 864-524, the application's not quite complete. I'm not sure if that matters in the motion.
It would probably be best to revise the motion to issue license once complete, or to revise the motion to close case.
Gayla, are we still what are we still waiting for? Is the origin?
But can we?
Yeah.
Okay.
So shall I make a revised motion?
Yeah, I think that would be cleanest, just to be clear on the record.
Okay. Madam Chair, in case number PT 864-05/24, I make a motion to close case.
I second that motion.
Tim,
Aye.
Aaron,
Aye.
Sandra,
Aye.
Michael,
Aye.
Susan.
Aye.
The revised motion carries unanimously. Okay, with that, Madam Chair, one note on the screen and for any members of the public watching currently, the next public board meetings are listed on the page. As noted previously in the meeting, the board may change these dates to address meeting in person or finding a day that might be possible. So these are the scheduled meetings, but subject to change.
Great, thank you. So the time is 1:09 and this meeting of the Oregon Board of Physical Therapy is adjourned.